Hello students, welcome to this class. And in this class, we are going to look at treaty as a source of international law, as we looked at it briefly in the first chapter. So the purpose of this chapter is for you to understand how treaties function as binding legal agreements between states and international actors, and how they also go ahead to create, regulate, and govern rights and obligations under international law. So these are the objectives for this chapter. You can pause and read through. So let us look at the definition of a treaty. So a treaty is a formally concluded and ratified agreement between states. But Article 2, Paragraph 1, Section A of the Vienna Convention on the Law of International Treaties defines treaty as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation, treaty is a formally concluded and ratified agreement between states. So let's have a brief overview. So the foremost source of international law is international treaties as laid down in Article 38 of the International Court of Justice Statute. So Article 38 refers to international conventions, whether general or particular, establishing rules expressly recognized by the contracting states. Conventions, international agreements, pacts, general acts, charters, declarations, and covenants are some of the various designations of treaty. So there are multifarious names which describe a comparable action, namely the constitution of written agreements by which the states willingly bind themselves legally to act in a certain way or set up a specific relation as between themselves. So it has to be noted that terminology is not a determinant factor as to the character of an international agreement or undertaking, and that international agreement may take a number of forms and be given a diversity of names. So while arriving at the nature of the act or transaction in question, the court must have regard to its actual terms and to the particular circumstances in which it was drawn up. So whether it is general or special, what matters is that it establishes rules expressly recognized by the contesting states. So the various titles assigned to these international instruments does not have any overriding legal effects, and the title may follow habitual uses or may relate to the particular character or importance sought to be attributed to the instrument by its parties, and the degree for formality chosen will depend upon the gravity of the problems dealt with and upon the political implications and the intent of the parties. So, for example, both the 1969 Vienna Convention and the 1986 Vienna Convention do not distinguish between the different designations of these instruments, but instead their rules apply to all those instruments as long as they meet certain common requirements. So let us look at the relevance of treaties as source of international law. So the United Charter lays down its determination to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. And thus, a treaty is an important source of international law creating legal obligations on the parties to the same, and they are bound to adhere and respect their treaty obligations. So, consent to a treaty may be expressed by signature, may be ratification or accession, and binding on the parties to it. So the principle that treaties are binding on the parties and have to be followed in a good faith is derived from a rule of customary international law called as Pacta Sant Servanda. So treaties could be a direct source of international law or reflective of a customary or general principle of law as evidence. So let us look at the law of treaties. So treaties are the principal source of international rights and obligations, and every state is a party to hundreds of treaties, bilateral and multilateral. So treaties regulate practically every aspect of state behavior in terms of peace and in terms of war. So let us look at codification of the law of treaties. So the law of treaties has been codified. For example, the Vienna Convention on the Law of Treaties was signed at Vienna on 23rd May 1969 and entered into force on 27th January 1980 after being ratified by 35 states. So the preamble to the 1969 Vienna Convention provides, however, that the rules of customary international law will continue to govern questions not regulated by the provisions of the present convention. So the 1969 Vienna Convention on the Law of Treaties applies only to treaties concluded by states. So an addition treaty dealing with treaties concluded between states and international organizations or between international organizations was signed in 1986 in Vienna. So it has not yet entered into force. So let us look at the types of treaties. So we have bilateral treaties. So these ones are concluded between two states or entities. So it may have two or more parties. For instance, the bilateral treaties between Switzerland and European Union following the Swiss rejection of the European Economic Area Agreement. Also, we have multilateral treaties, and the multilateral treaty is concluded among several countries. So the agreement establishes rights and obligations between each party and every other party. So each party owes the same obligations to all other parties except to the extent that they have stated reservations. So example is a convention relating to the status of refugees. Also the UN Convention on the Law of the Sea, and also there is Geneva Conventions and more others. So there is also universal treaties. So this one concludes among almost all the countries. So for example, UN Charter or Convention on International Trade in Endangered Species of Fauna and Flora, which has almost 160 parties. So on rare cases, a treaty may also be terminated, and this can be due to consequences of its material breach by one of the parties, and that is in Article 60. So also because of the supervening impossibility of performance resulting from the permanent disappearance or destruction of an object indispensable for the execution of the treaty as in Article 61. So these factors may also lead to termination of a treaty. So I have attached the reading materials for this chapter in case you want to read more or go and make further research. Use these materials. That's all for now. Thank you.